For the next few weeks, Nigeria's judiciary is expected to take center stage as it sits over several petitions arising from the recently concluded general elections. At the moment, federal courts are busying themselves with determining outstanding cases bordering on procedure and preparing the grounds for the election tribunals to focus on the merits and demerits of the complaints surrounding the elections. Meanwhile, the need for judicial reform has been at the forefront of agitations from concerned stakeholders. Justice Taiwo is a retired federal high court judge, and he joins us now to take a look at judicial reform and the calls for the reformation of Nigeria's criminal justice system. Good to have you here. Thank you so much for joining us this afternoon, sir.
Thank you very much for having me.
Well, there are a myriad of...
Thank you for having me.
Well, it's good to have you here. There are a myriad of situations that plague the federal high court and the judicial system in general, specifically for individuals who are trying to get legal help. It's insufficient. Judicial processes can be slow for individuals who are already locked up. It's expensive for pretrial detention. We know there's overcrowding of the prisons, and the disturbing fact that 2/3 of the inmates in prison are yet to sit for trial. We do know that there are many reforms that have been instituted, specifically the 2015 Administration of Criminal Justice Act. Can you speak to us about its implementation and the gains so far, even though some remarks that are coming from those stables say that it hasn't worked as well as we would like to? So just your opinion on how we can go forward with that.
Well, my opinion, actually, is that looking at the Administration of Criminal Justice Act, which we use the Federal High Court, there have been a little bit of successes, but I will say that it has not really taken root in the sense that the law is not being followed to the letter by all stakeholders. And when I mean all stakeholders, not only the judiciary is at fault. Other stakeholders are also involved in the process of making sure that this law works. And any shortcoming of the law cannot be laid barefaced at the doors of the judiciary. But I know that we'll get there one day, and it's still been fine-tuned over and over and over again. So I'm sure we'll get there one day.
Very good, Justice Taiwo. Now, while you were a judge at the Federal High Court, what were the major aspects of the judiciary there at that level that needed, urgent reform and beyond?
Well, I would say the issue of equipping the courts with modern-day technology that will enhance speedy dispensation of justice. Yes, we have stenographers. Some courts have, some don't have. And this slows down the pace of judicial judgments and process. And I still see that most of the things we do are still not, we do it with, as if we're still in the past. And when I mean we're still in the past, the procedure or the process is not in tune with the modern day technology that is available. But I know that some courts have been retrofitted. They've been retrofitted for technology and is being used, but not all the courts. So I believe that the procedure or the process of justice administration must tally with the modern day technology. And that means a lot of money, and that's where the executive or the judiciary or whoever is responsible for that has to come in.
And you did say that it might be the judiciary or the executive that might be a stumbling block to modernizing these court systems and introducing technology, and it also could be an issue of money. But what are some other reforms that could be looked into apart from technology?
Oh, okay. Like, for instance, it's being done now by the Attorney General of the Federation. And of course, and I'm sure that the president of the NBA actually informed the gathering at one of the valedictory sessions of what is being done about the salaries and salaries of judges, which I consider not too good. If you actually look at it, and if you want to be truthful to ourselves, and if you want to tell ourselves the truth, it's not too good. So all these reforms, like housing, owner-occupier, especially at the federal level, yes, Lagos State have done it, Rivers State has done it, Akwa Ibom, Ogun State, but these are states. What about at the federal level? These are the reforms that will cushion the effects of retirees like us, and of course, that will enhance justice delivery when the judge knows that, oh, yes, I can work well because this and this and this has been put in place for me. And of course, they have to train and retrain the staff. They have to train and retrain the staff. We do a lot of training, both within and outside the country. And I can tell you that the National Judicial Institute is trying its best in conjunction with the Attorney General of the Federation and the Chief Judge of the Federal High Court to make sure that judges are trained, especially over and over again on modern, not only on modern technology, but also the laws as evolves, you know. So that's it. All these things are, these reforms are things I believe ought to be put in place or should be enhanced so that the justice delivery system will be something that every one of us will be proud of.
Very good, Justice Taiwo. And it is often said that there ought to be a measure of independence between the three arms of government. But where is the place of Parliament or legislature when it comes to judicial reform as it relates to the Constitution? Is there any synergy between the both arms of government?
Yes, when it comes to that, you know, the federal, the legislature has to do some little bit of work in making sure that the judiciary is not starved of funds. And I believe, and it's been proposed in many quarters, that the judiciary should be as free as the executive and the legislature. So the funding of the judiciary should not be tied down or bogged down by legislative or executive bureaucracies. But I know that if the legislature and the judiciary, if they can synergize more than they are at the present, it will be a thing of joy for all of us in the delivery of justice.
All right, I'd like to steer the conversation just a little bit, just picking your brain as we know you are retired, but we do know that you handled quite a few high-profile cases in your time that were controversial. And we do know that we're heading into, or we are in quite a heavily politicized season, and a season where a lot of cases will be going to court. We know we all watch the news. So first of all, in your opinion, is the Federal Capital Territory, should it be considered a state? And I ask this because, like I said, we know a lot of these cases are going to court, and I also want you to help assess the grounds under which some of the parties are taking their cases to the tribunal without stepping on any legal toes. What's your opinion on that?
Yes, you see, I'm in a very tight situation with your question. One, as a retired judge, and the fact that I know the rules of the game. Yes, I've read a lot of papers, newspaper reports on this issue of the standing of the Federal Capital Territory. But you see, my own way of looking at it is that once a matter is sub judice, I do not think people should dabble into it. These are very, very touchy issues that I would prefer that be left for the judiciary or for the courts to determine, because the papers have been filed. So whichever way I look at it, I don't want to run foul of the fact that I must be careful of what I say, especially knowing the rules of the game, that when a matter is before the court, you don't discuss it. That's what I was taught at the law school, and that's what I believe should operate at the moment. So I would not want to jump into the fray of discussing matters that are already before the court. Papers have been filed. So I believe that we should leave the issue to the court to decide. Whatever I say is of no moment, and I won't want to say anything that will jeopardize any of the parties, and I won't want to say anything that will put me in a sort of a cul-de-sac. So I want to just pass by, and let's just treat that answer as it is.
Fair enough.
Very good, Justice Taiwo. Now, I was still talking about the criminal justice system. Long detentions without trial and, of course, a backlog of cases is a challenge over time. How has the judiciary fared in reducing this problem? And there's also the thorny issue of prison congestion as well. You talked about the manual ways of doing things, but going forward, what's the way out?
Yes, the way out of that is that when I was on the bench, I noticed a lot of things. Now, the issue of bringing accused persons to the court is not in the hands of the judiciary. It's in the hands of the authorities entrusted with that power. Now, when they bring them to court, and people expect, of course, judges to either grant them bail or not grant them bail, depending on the gravity of the offense. But I must just say that there's no offense that is not bailable, depending on the circumstances and the facts before the court. And of course, the opposition and the fears of the prosecution as to the standing of the person before the court. So the issue of decongesting the court is an issue that every stakeholder must hold there. There are some cases, there are some situations where the accused person do not have to be taken to the prison. If you know where an accused person lives, especially if they are just minor offenses, when you go to prison, you see people in detention for maybe crossing the road, minor traffic offenses. These are things that clog the wheel of justice. And of course, the ACJA have laid down the procedure. Bail can be granted by the police. Bail can be granted by the court. Depends on the gravity of the charges before or against the person. So I honestly feel that the issue of decongesting the prisons is not is not caused by the judicial arm of government. When you file a charge before the court and you follow up on it, then it makes it seamless for the court to decide as timeous as possible whether to grant bail. And of course, I want to also say that some other stakeholders, let me say now, some lawyers can be a clog in the wheel of justice. Some lawyers know how to buy time. They want to buy time for their clients. And they will not come to court. They come to court, they seek for adjournments when there should not be adjournments. When adjournments are not meant to be granted. And of course, the court too can put its foot down in many cases. That no, I'm going to hear this case today. If the prosecution is not ready, then I'll strike it out. If the defense is not ready, I'll go ahead with it. Now, when a judge has to be careful in doing this, because if the prosecution comes and delays a matter, and the court strikes out the matter, the public will not understand the reason why the judge has done that. Oh, then you'll have some people will now start backbiting, or they will be blackmailing the judiciary. Oh, why did the judge do that? Why would the judge do that when you are not ready to prosecute your case? So the prosecution has its faults in this matter, and so also the defense. The fault of the judge is minimal. It's minimal to the extent to which the court can take in a day. Where a judge has about 20 cases or 30 cases to hear in a day, even with the most careful case management, how far can the court go?
Very, very good, Justice Taiwo. If I may, I'm sorry, sir. If I may interject and come in there, but do you think criminals are being given the proper rehabilitation in prison, or they're worse off? By the time they get back into society, regarding our prison system in Nigeria?
As far as I'm concerned, there's no rehabilitation. As far as I'm concerned, it's more like we breed more criminals here than necessary. Because when a guy is in prison, what trade can he learn? The prisons in Nigeria are meant to be reformatory. They are meant to reform the accused person. But it's not so here. Cases abound of somebody imprisoned, released today, the next day is on the street doing the same thing that he went to prison for in the first place. Why did it happen? It's because some of these people, when they even go out, some even don't have anywhere to go. It's like you are pushing the criminal back to the street. So a lot has to be done on rehabilitation and reformation of those imprisoned in Nigeria. There are some other issues also, and that is the issue of compensation for the accused or for the victims. It's not done here, except maybe in high-profile cases. But when it comes to petty cases, like for instance, I remember there was the matter of one guy somewhere in Ekiti took a picture of a lady, put it on a Facebook for the whole world to see. Of course, he was charged to court under the Cybercrime Act. And I convicted him and also fined him. But in that law, there is no compensation for the victim. The fine is payable to the coffers of the federal government of Nigeria. So we have a lot of things to cover, and we have a lot of road to go when it comes to reformation, rehabilitation, and then compensation for the victim of crime in Nigeria. I believe people should now sit down and get a way to work towards that. Certainly.
Certainly a lot of ways to go within the judicial system, but very glad to have you on the show with us and to have this discussion. Thank you so much for joining us, retired Federal High Court Judge Justice Taiwo.